AM 650 presents You and the Law, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Welcome to the program. It's a pleasure to be back with you. David Hobbs and Ian Giroday are with us in the studio with You and the Law, and today we're going to talk wills and estates. David Hobbs and Ian Giroday, welcome, guys. It's great to see you. David?
Thank you, Sterling.
Tell us a little bit about yourself, sir. You're the first one in the partnership name, so you get to go first. David, tell us a little bit about yourself and your experience with the law in British Columbia.
Well, it brings me back to flying on a plane from the Queen Charlotte's to Vancouver when I was about probably 19 or 20 years old, and my mother always said that I had to go to university, so I decided to stop working for law grading in those days and went to UBC. And did my undergraduate there, and I was the president of the law school at UBC. And then I started working with a mainstream law firm in Vancouver and articled and was an associate, became a partner, and then after about 10 years I started my own law firm with a friend of mine, and we did that for 17 years, and we grew the firm from a couple people to about 25 people, and Ian worked with us in those days. And then Ian and I broke off and started Hobbs Giroday about 8 years ago.
Have you always been, you're talking now, taking you back to your grad out of law school days, and you go to work for a well-known Vancouver firm. Was that a general practice, or did you get right into wills and estates right from the get-go, David?
Well, that was a general practice, and we had solicitors and barristers as well. We were litigators or barristers, and we were exposed to estate litigation in those days. I would say it's not as common then as it is now as a species of litigation, but our solicitors were drafting wills and dealing with estates, and when problems arose, the litigators would be called in to help.
All right. And Ian, how about you? You're a member of the firm, and you have been together with David Hobbs now for 7 or 8 years as Hobbs Giroday. Where were you before that?
Well, in fact, David and I go back to the mid-'80s together, because when I came out of law school 3 or so years after David, he was at the firm that I articled at, and we were then in practice together at this larger firm for 3 or 4 years. David went off to build his own practice, and I joined him about 10 years later.
All right. And was your, as David has indicated, his interest in the whole area of wills and estates has been constant for a long time. Same with you, or were you drawn to it for other reasons?
Well, at the larger firm that we worked at, we had a very strong estate planning group, solicitors group, and they wanted to develop estate litigation through the 90s. So that's where certainly where I cut my teeth was doing some estate litigation at the larger firm, and then when I joined David, we carried on with it, and it's become more and more an emphasis of our practice.
And by the way, friends, if you're listening to Ian and you're going, Giroday, I know that name. Yes, it was Paul Giroday, Ian's cousin, who used to play for the BC Lions, if you're tweaking on that last name like I did. But now, talk to us a little bit about the firm, Hobbs Giroday, because you're not, you talked just a moment ago about estate planning and the preparation of wills and that sort of thing. That's not the sort of work that Hobbs Giroday does, David. You come in after all of that work has been done and litigate wills. Talk to us about the nature of the work.
Well, people come to us, usually there's obviously been a death in the family, which triggers a will. Wills take effect when people pass away. And the people that come to see us might be the executor of the will having some trouble with the administration of the estate, or it might be someone who's either in the will or not in the will, who's disappointed about how the situation they've been left in. And this brings us into all sorts of issues like the validity of the will or will's variation or other issues that may impact the interest that someone has in an estate.
Okay.
So we deal with those problems. We study the problems and advise people on whether they have any rights to pursue a particular claim.
All right. Now, Ian, given that David's just described the nature of the work, I want to go back a step or two. How many people end their lives without a will? What percentage of the population? Just if you can grab one out of thin air. It seems to me, and a lot of people, that it would be a normal, practical thing to do. I get the impression that not everybody's on side with that, or perhaps it's a detail they just never quite got around to.
Right, and To tell you the truth, Sterling, I'd be very hard put to put a percentage on the general population.
But it does happen, doesn't it?
Absolutely. And there's laws dealing with what we call intestacies, people who die without a will.
What happens in those cases? Now, and because I want to get into some of the litigation work that you do, but what happens if a person dies and there is no will? There's no direction to what to do with my estate. What happens then?
Well, then it's governed by written law. There's an act called the Estate Administration Act in British Columbia, which allows for the appointment of an administrator to deal with the estate. And frankly, the distribution of the estate is dealt with through that statute.
Okay.
So it's sort of it's divided out in a certain fashion based on the number of, whether there's a spouse, whether there's children and the number of children and that sort of thing.
Okay. Now, David, in the case even where a person hasn't created a will, and so the estate then falls into the written law that Ian has just described, do people who are can people dispute the findings or the way that the estate is distributed according to the law? If I'm a person who feels entitled to something out of this estate, despite the fact that there was no will, and there's some kind of resolution that leaves me out of the picture, can I come back, or is the law, is that the last word?
Well, it's funny, Sterling, that the types of disputes you get with intestacy usually involve people establishing that they're in the category of the family members that are entitled to receive a benefit in the intestacy. So you get people showing up and saying, I am the child of the deceased. Nobody knew.
Okay.
Or you get a fellow maybe has a housekeeper or something. The housekeeper says, well, really, I'm the common law spouse. I'm not just a housekeeper. So you get people creating disputes about their status and that they fit within the scheme because they are the spouse, or they're a long lost child, or and so on. But because there's no will to vary. There's no will to dispute, and the statute really governs, and the main area of dispute is who are the people that fit within the statute.
Okay.
Yeah.
All right. Interesting stuff. Now, most of the work that Hobbs Giroday do, of course, is dealing with existing wills that are in some kind of dispute. What is the typical, Ian, dispute? What's the main reason for people coming to you going, hey, wait just a second here, I'm out of the will and that's not the way it's supposed to be?
Right. Well, there's more than one.
Okay.
But assuming that the will is valid, and that's something that we look at the outset, but assuming that the will is valid, the main reason someone would come to us as a disappointed beneficiary would be to see if they can do something in the law that would allow them to receive more than they were bequested under the will, given under the will. And that's, assuming the will's valid, that's limited to an ability of a spouse, and that includes a common law spouse, or children to seek to vary the will.
So there are only certain categories of individuals who can come forward to dispute the will?
Yeah, I would put it this way, Sterling, as I'd say, is the will valid or not, and we can have a big discussion about that.
That's coming up.
You can vary a will if you fit within the parameters of that. And the other interesting topic is the estate itself, because when we die, our estate is what we own, and what we have an interest in. And sometimes people create gifts before they pass away.
True, yep.
And so someone comes along and challenges the gift. They say, that's not a gift. That really should be part of that person's estate. Put it back where it was. And so that can be another area of dispute. So I would say those are three big areas that disputes exist in.
Okay, we're talking with David Hobbs and Ian Giroday here on You in the Law in this edition. And geez, Ian, let's go back to what you were just mentioning, because David just said this is a whole area of subject matter all by itself. Is or was the will valid? What would make a will invalid?
There can be various reasons why a will could be invalid. The first one would be there are certain formalities that a will must follow in order to be valid under the Wills Act of British Columbia.
Okay.
And of course, most people are familiar with the idea that the will has to be signed by the will maker. It has to be witnessed by two people who are present when the will maker signs the will, and who sign the will in the presence of the will maker.
Do they have to have read the will, Ian, or is it just necessary to be in the room when the person signed the will?
They don't have to have read the will.
Okay, all right. Just witness the signature then.
Right.
Okay.
So there's Wills Act formalities, and then there are the next issue for consideration is, did the will maker have the capacity to make the will?
The old sound mind and body aspect of will making.
Exactly. And there's a whole body of law around that.
I'm sure.
And then sometimes we look at wills where there's capacity on its face, but there's reason to believe that the will maker's mind was unduly influenced by someone who, of course, turns out to be a substantial beneficiary under that will.
Mm-hmm. And of course, Hollywood is full of stories of that, and so are the tabs in the supermarket. But, truth is always stranger than fiction, David, and most of these stories have more than a grain of truth to them. That even though they are sensationalized, etc., some person has been trying to manipulate the system to their own advantage in a lot of these cases, correct?
Yes, I agree. There's manipulation, Sterling, but on the other hand, also there's vulnerability. And so obviously it's easier to manipulate the vulnerable than the not so vulnerable. And when we think of vulnerability in this arena, we're quite often thinking of the elderly and people living in the basements of people's homes, people who can't get out to go shopping, that type of thing. And they're very vulnerable to the needs and so on of people who are caring for them. And so you get this question, is it manipulation? Is it vulnerability? Is someone trying to help? And that's the puzzle that we are looking at quite often.
In the course of the discussion about whether or not a will is valid, are there, and you talked, Ian, about certain formula that have to be followed, and it has to be done in such and such a way, otherwise you're going to run into legal problems and probably Hobbs Giroday in the process. So what then should people do, and I'm not, to get it done right the first time? What are the basics? And I know this isn't your area of specialized practice, but you see the other side of the coin every day. So what happened? What do they mostly do wrong?
Well, in terms of validity, they've either tried to save a few dollars and used a will kit and missed some formality that they needed to comply with.
Okay.
Or they may have gone to a professional like a notary public or a lawyer, perhaps someone who didn't have a lot of experience with wills or just doesn't do a very good job of ensuring that the will maker had the capacity to make the will.
Okay. So there's some kind of test involved. If I go to a lawyer and say, look, time to do a will, that lawyer is somehow obliged to make sure I'm capable of doing precisely what I'm asking that individual to do on my behalf, correct?
Correct. And sometimes what we see in our business, our end of the business, is the will maker may have had a relationship with a lawyer or someone for many years, but on the occasion that they make the will that everyone's fighting about, someone took them off to someone they didn't know and normally didn't deal with. And
so there is some kind of competency test involved with making a will. If you sit down with a lawyer, perhaps an individual you've never met before, that person should be is somehow obliged to determine through a series of questions that you're entirely capable of doing this will business that you're here to do, right?
Definitely, it's the duty of the lawyer or notary taking instructions to draft a will to test the capacity or competency of the will maker by asking questions. It's to make sure that the person knows what their assets are, what things are worth, what the will is doing, i.e. distributing their assets on death and that sort of thing. They're supposed to ask those questions and make that assessment.
Okay, what percent, and I keep doing this to you, Ian, and you keep rolling your eyes at me, and I don't blame you, but what percentage of people mess up, don't get the will done properly?
Oh, it would be a small percentage, but you have to appreciate we see a skewed population come into our office because we're already dealing with a situation where someone is suspicious that the will isn't valid for some reason.
Okay.
So I would think that it'd be a very small percentage, but enough to keep a lot of estate litigators busy in the city of Vancouver and elsewhere.
David?
I'd answer your question this way. It's like asking how many people have car accidents. There's lots of people driving around, but we all know people have car accidents.
Sure.
So I would say it's probably similar in that sense.
A comparable sort of percentage. Interesting. Yeah. Need to take a quick break. You're listening to You and the Law here on AM 650. I'm Sterling Fox, joined in studio by David Hobbs and Ian Giroday, and we'll be right back.
This is You and the Law. There's more of the show still ahead on AM 650.